Chair Spencer,
Here.
Representatives Alperman, Allen, Davis,
Present.
Fitzpatrick, Flanagan, May, Parkinson,
Here.
Runyons,
Here.
Weeman,
Here.
Alperman walk through the door. Having established a quorum, we will now hear House Bill 1530, sponsor Wanda Brown.
Thank you, Mr. Chairman. Wanda Brown, District 57, just for the record. Thank you all for hearing my bill. House Bill 1530 is one we heard last year, and this is legislation that will keep Missouri in compliance with the federal government concerning the recovery of overpayment of fraud and non-fraud unemployment benefits. And without this fix, the cost to Missouri employers will be nearly $1 billion a year. What it does is it gives the state the ability through federal and state income taxes to recover the overpayment of unemployment benefits. And it does keep us in compliance with the federal government. So, and also, this will allow the Department of Employment Security to collect nearly $2 million a year for the unemployment trust fund. So if there are any questions, I'd be glad to answer them.
Does the committee have any questions? Representative Parkinson.
Jim Clark.
Please.
Is this a recent change to federal law?
This happened about 2 years ago. We did have this bill through last year too.
Okay.
So they just want us to come in compliance with some of their wording.
Is this a change to federal statute or via executive fiat?
I am not sure. I do have someone from Employment Security that could probably answer that much better than I.
Thank you.
Are there any other questions of the sponsor of the bill? Seeing none, is there anyone here that would like to testify in favor of the bill? And I would like to remind everyone they need a witness form filled out.
Mr. Chairman, members of the committee, my name is Jim Benoist. I'm the Director of Legislative Affairs, and I'm testifying in support of House Bill 1530. The representative covered just about everything. One thing I did want to mention, for those of you who have the fiscal bill in front of you, the Federal Unemployment Tax Act, FUTA, imposes a 6% payroll tax on Missouri businesses. Most businesses never pay the full 6% due to tax credits they receive from the payment of state unemployment taxes and for paying reduced rates under an improved rating system. The tax credits they're able to receive top out, for lack of a better term, at 5.4%. So if the Division of Employment Security is not compliant with federal law and we lose certification, Missouri businesses will no longer have access to those credits. That is what, in regards to what the representative was referencing, into the $1 billion they would have to pay extra. That's referenced in the fiscal law. That's where that $1 billion comes from. So, and to Representative Parson, to your question, it is a federal statutory change, so it was not through an executive action or anything like that. So, with that, I'm free to take any questions, concerns.
Representative Fitzpatrick.
Good part,
Please.
I'm a little rusty on my funds. So is the unemployment compensation fund, is that where we pay benefits from?
Yes.
And then
Yes, sir.
what's the special employment security fund?
Where is that at here?
Just reading the summary, it says the 15% of the total amount of benefits fraudulently obtained to be deposited into the unemployment compensation fund, and the remaining penalty amount must be credited to the special employment security fund.
That's something I'm gonna have to get back with you on. I'm not sure of the exact difference between those, but
Because it seems like the whole bill takes, I mean, right now, the money is being deposited in a special employment security fund. And this bill, the only thing that's changing is it's making 15% of that money be deposited into the unemployment compensation fund, so.
So the special employment security fund is different from what we pay out for unemployment benefits. The special employment security fund, we use that to cover expenses that we can't cover through our base grant fund.
So what would be an example of those expenses? Like,
It could be anything from,
yeah, you want
it
to
could be,
you want to just come up, I mean, it's up to the chair, but if you want to testify on that.
it could be anything, salaries, E&E expenses, telephone bills, anything we can't cover with our base grant fund.
And your base grant fund is,
From the federal government.
You get a grant from the feds to operate an unemployment
Yes, sir.
security program?
Yes, sir.
Got it. And you probably don't know how that fund gets money put into it other than this mechanism, do you?
It's federal dollars for the administration. Okay, you're talking about the special E&S or the?
Yeah, the special employment security fund. How does that fund get money put in it other than through this collection of overpayment? This collection of overpayment effort.
Okay, I'm gonna have to defer to
Here, sit up here, please.
go ahead.
Oh, no. Stay there.
Sorry. That's okay.
Would you repeat the question, please?
I just wanted to know how that special employment security fund gets money in. I mean, how does money get into that fund other than by the collection of these overpayments?
Penalties and interest. Employers who do not file their contribution wage report timely are subject to a penalty. Though when we recover those penalty amounts, they go to special ES funds.
Okay, so that's,
And also penalties on overpayments that are not directed to the trust fund go to the special ES fund. So penalty and interest, and all interest on unpaid taxes.
okay. Got it. So all this bill does is diverts a little bit of money away from that fund and puts it into the unemployment compensation fund.
The actual change you're referencing is another requirement under federal law, and we actually accomplished this through a regulation back in, I believe it was 2012, maybe 2011. And since the change that House Bill 1530 opens up Section 288-380, we thought we'd go ahead and codify the language in regulation, put it in statute where we felt it was more appropriate.
Okay. So the other parts of this bill that aren't included are other than this, that I'm talking about, other than the redirection of those funds.
Yes, yes. This bill also allows the Division of Employment Security to use the Federal Treasury Offset Program to collect fraud and non-fraud overpayments. Right now, due to a Supreme Court ruling, the division cannot use the Federal Tax Intercept Program, Treasury Offset Program, to collect non-fraud overpayments. And federal law requires states to use the Treasury Offset Program to collect non-fraud overpayments due to benefit year earnings.
And just what's your best description of that, of the Federal Treasury Offset or the Treasury Offset Program? What is that again?
So it's outlined in subsection 14. That would be through billing, federal and set offs against federal and state tax returns, intercepts of lottery winnings, and garnishment.
Okay.
In summary, it allows the division to offset individuals' federal tax returns if they owe the unemployment trust fund money.
Okay. All right, thank you.
Can you state your name, sir, and your affiliation?
Spencer Clark, Deputy Director, Missouri Division of Employment Security.
Thank you very much. Does anyone else have a question for these witnesses? Seeing none, thank you very much. Is there anyone else to testify in favor of this bill?
Mr. Chairman, members of the committee, my name is David Overbelt. I'm a registered lobbyist for Associated Industries of Missouri, Missouri Retailers Association, and Missouri Grocers Association, and we'd like to go on record in support of the federal compliance bill.
Any questions of this witness? Seeing none, thank you. Is there anyone else to testify in favor of this bill? Seeing none, is there anyone to testify in opposition of this bill? Seeing none, is there anyone here to testify for informational purposes only? Seeing none, I declare that House Bill 1530's hearing is over. The committee will now move to Employment Security Executive Session. I move that House Bill 1530 be voted do pass. Is there any discussion? Yes, sir. Please.
Did this bill just die in the Senate because of the shutdown last year?
Yes,
Okay, thank you.
thank you.
Any other discussion? Seeing none, please call the roll.
Chair Brown. Aye. Vice Chair Spencer.
Aye.
Representatives Alferman, Allen, Davis.
Aye.
Fitzpatrick.
Aye.
Flanagan. May. Parkinson.
Aye.
Runyons.
Aye.
Weeman.
Aye.
By your vote of 7-0, you voted for this bill to be passed. I now make a motion that we move House Bill 1530 to be voted by consent. Will you please call the roll?
Chair Brown. Aye. Vice Chair Spencer.
Aye.
Representatives Alferman, Allen, Davis.
Aye.
Fitzpatrick.
Aye.
Flanagan. May. Parkinson.
Aye.
Runyons.
Aye.
Weeman.
Aye.
By a vote of 7-0, this bill passes by consent. We'll now move out of executive session and going back to hearing bills. We will now hear House Bill 1528 by Wanda Bryan.
Thank you, Mr. Chairman. What House Bill 1528 does is add any person or corporation in the construction industry to the definition of employer. Currently, right now, every business in Missouri except construction workers, if they have less than 5 employees, do not have to pay work comp insurance. But for some reason, when this bill was passed, they left construction workers out. So in the rural areas where there are many small construction companies, less than 5 employees, their work comp bills are actually putting them out of business. They're unable to hire people. They are actually, it's shutting down construction jobs in the rural areas. And I've heard the argument that if someone on these construction jobs gets hurt, for some reason they think construction workers don't have health insurance. And they have said that if someone gets hurt on the job, that taxpayers then have to foot their medical bills. But in essence, what this has done in the rural areas is shut them down so that they've had to go on welfare. Then the state does have to take care of their health insurance, their food bill, their housing bills, their gas bill, and their light bills. So it's cost taxpayers by far more than what they had gained on this. In the grand bargain of this, this was something that had included, this was, the whole intent of this was big insurance, big labor, and big employers, big retailers. That was the grand bargain of this work comp bill when it was implemented. The intent of this was not to shut down small construction workers, and this is something that I think we need to change. It is hurting employment in our small areas. So if there are any questions, I'd be glad to answer them.
Questions, Representative Davis,
To Griffin Inquirer.
please.
Most of our local small business construction companies are mom, dad, son, cousin, etc. So this is primarily going to be helping the mom and pops, the small construction companies. Correct?
Yes. And I would also, thank you, Representative, I'd like to point out there is an annual report here by the Missouri Division of Workers' Comp that in every case of first reports by injury, most of the claims are healthcare and social assistance, manufacturing, retail trade, and public administration, educational services, and accommodation and food services. By far more injuries than construction workers. In the claims by industry, manufacturing, healthcare and social assistance, public administration, retail trade, transportation, and warehousing have by far more injuries than construction workers do.
And also with the implementation of the Affordable Care Act, everything is Garden of Eden, and we've solved all those problems, correct?
Yes,
Thank you.
Thank you.
Well, it looks like I've taken over responsibilities as chair of the committee now. So any further questions?
Inquire.
Proceed.
Just one quick question. Have you ever filed for workman's comp, got hurt on the job, went to the doctor, went to the emergency room? What's the first question they ask you? Were you injured on the job?
Okay.
That is always on the questionnaires. Were you injured on the job? And as soon as you say, I was injured on the job, it's going to go to workman's comp. Your personal health care is not going to pay for it. So you're going to lose, you're going to break the contractors, but you're going to also break the individuals working for them. This is not good, because that's the first question that's asked.
But Representative, I beg to differ. If you break your leg here, your insurance will take care of you. This is breaking people. In my area, $28,000 is the average pay. We have construction workers that are paying $2,000 a month for work comp. It is going up and it's going up and it's going up. They've had to drop their health care insurance. They've had to go on welfare. They've had to go on food stamps.
And they're going to continue to do it if they get hurt on the job, because they're not going to be accepted. Or if they're making $2,000 a month, they can't pay for health insurance.
Exactly, nor can they pay for the outlandish work comp rates. So this is just basically shut down all
I think we need to come
construction.
up with a better plan, because all you're going to do is break the contractor, and you're also going to bankrupt the individuals.
But that is up to the contractor, actually. And with all due respect, these reports from the Missouri Division of Workers' Compensation, a retailer does not have to have work comp. Healthcare workers, if they have less than 5 employees, do not have to have work comp. So why would we pick construction workers when they have by far less injuries than many
And
trades?
probably that's because, and especially where you have union contractors, they are trained. They are trained in explosive safeties. They have first aid. They have it all. They don't they enforce those rules.
Yeah.
But you've got these smaller contractors, they don't pay attention to those.
You know what, I
I've seen
beg to differ with that. If you want me to bring out the list of buildings that have collapsed that have been built by union labor, I will do that.
Okay.
So, and if you can name me one that's collapsed that was built by private labor, I would like to see that.
I got one. Way more City Hall, they cut it on their own. Not
That
green.
has to be union,
Greenwood
that has to be
City Hall.
union labor.
No,
So, but,
Greenwood City Hall collapsed.
and Hyatt Regency collapsed, and as about 20 other major buildings and lives were lost.
I'm very familiar with the hire. That was an engineering flaw.
Representative Young, any other questions pertinent to this bill? Okay. Any other questions from the committee? Seeing none, I'll go ahead and proceed with, is there anyone here today that would like to testify in favor of House Bill 1528? Seeing none, is there anyone here today that would like to testify in opposition to House Bill 1528?
Thank you. My name is Mark Moreland. I'm on the Executive Committee of the Missouri Association of Trial Attorneys, and we oppose this bill. For the last 32 years, I've represented people who get hurt in workers' compensation. My office has 3 employees, and I do purchase workers' compensation insurance. I want to correct a couple of things that Representative Brown has said. First, healthcare does not cover work-related injuries, whether those injuries are covered by workers' compensation policies or not. So if a roofer who is not covered falls off the roof, his health insurance, should he have it, will not cover it because it is a work-related injury. And general healthcare policies have exclusions for work-related injuries. I deal with this every day. I will tell you they don't cover it. I get calls every day of people whose claims have been denied, who then go to a doctor or a hospital, they can't even get seen because as soon as they're asked, is this work related, the company, when they say yes it is, that's it. There's an exclusion. The hospital knows that. They send them out the door. I've seen hospitals who they originally get paid by health insurance, then they realize, wait a minute, this could be work related. That big health insurance carrier comes in and says, give us our money back. So I've had bills that were originally zero or near zero. All of a sudden, that bill pops back up because that healthcare provider has taken the money back from the hospital. You all already know that rural healthcare providers are having difficulty being reimbursed when people come into their systems uninsured. Some of that reimbursement has gone away under the Affordable Care Act, and without the adoption of the Medicaid provisions of that act in this state, the hospitals are already having trouble getting reimbursed. This bill will shift the cost of those injured workers if those hospitals provide treatment in an emergency situation onto the backs of those hospitals. So that would be the first thing. Second thing is, workers' compensation provides an exclusive remedy for the worker. So if the worker falls off the roof, he can't go sue the contractor. He has to go under the workers' compensation insurance policy in order to get benefits. If that contractor doesn't have workers' compensation insurance, he can then be sued if he's contributed to the cause of that person's injury. And you all talk to me all the time about how lawsuits drive people out of business. I will tell you, this encourages lawsuits against small businesses who choose then not to have workers' compensation coverage. And then it kind of, so always talk about costs. I will tell you, the cost of workers' compensation insurance in this state has declined gradually over time over the last 10 years. You put in substantial revisions in the work comp statute in 2005. You made it more difficult to get benefits when a person got hurt at work. You raised the burden of proof for the injured employee to prove that his condition is work-related. Well, and what you said at the time, and what your predecessor said at the time, was you wanted to reduce workers' compensation costs. I argued with it. Well, you turned out to be right. You reduced the cost of workers' compensation. So I'm not going to sit here and say that, for a small business, insurance is not an expense. It certainly is an expense. But the risk that they run when they do not get workers' compensation, the risk they put themselves under, their families under. I mean, if they're a mom and pop, workers' comp is the cheapest disability insurance you can buy. If that father gets hurt on the job and can never work again, he gets a benefit 2/3 of his average wage for the rest of his life under that policy. It's the cheapest disability policies he can buy. And the other thing I would say is this. If a subcontractor, if a small subcontractor does not have workers' compensation insurance, he gets a job through a general contractor on a construction site, and his worker gets hurt, that worker can go after the general contractor's workers' compensation company, okay? So the cost has been shifted to the general contractor. Now what happens with that? That general contractor's insurance cost is based upon the number of employees that they have, the amount of wages that they pay. The cost that they pay for insurance, you figure in somebody else's employee. So it is a way to shift costs onto people that should not necessarily bear that burden. In this case, the general contractor. So I think for all of these reasons, it is a bad bill. I think it remains good policy in the state of Missouri to cover as many workers as you can under workers' compensation. It prevents lawsuits in the civil courts. It provides their families with immediate benefits that may save their home, that may buy them groceries. It provides medical treatment while at the same time there's cost containment in workers' compensation. The employer chooses the doctor. That doctor decides when a person is done treating and can go back to work. That doctor is the one that evaluates the person for disability. So it provides cost containment. It is still good policy to have people covered. And I think if there's anything that we should do, it's if there's some disparity and there's this thought that it's unfair that contractors are singled out, then perhaps everybody that has a business, one or more, ought to be required to have this coverage. I'm not required by the law. I buy it every year for myself and my employees. Because if I drive back today and I get an injury on a bad road, having done my job here, I want to know that my family's covered. Thank you.
Any questions for this witness? Representative McGuire.
So you got a construction company that it's husband, wife, and one son. Federal government says you're required now to pay health care insurance, whether you like it or not. So now they have to pay this extra amount of money out of their pocket, even though they are very healthy. They don't go to the doctor. They have their private doctor that they pay $25 and then saw them. But we're mandated now that federal government says, we don't care what you think, you're gonna have to pay health care insurance for you, your wife, and your kid. We also make them pay unemployment insurance, even though as owners of the business, they can never claim unemployment. You know, I own my own business and I've been paying unemployment I've owned the business for 27 years. If I were to shut down my business, even though I paid unemployment myself, I would not ever be able to recover any of those unemployment benefits as the owner of the business. But government mandates that they do that. Government mandates that this construction company pays for work comp insurance. So government mandates, and you got these small mom pop construction companies that we're mandating them out of business. The question I have is, who's responsible if somebody does get hurt on the job? The business is, correct?
Well, I think that's a broader.
I mean, as a trial attorney, I'm sure you could probably have a client that would be able to sue mom because you got hurt on the job and mom's not wanting to pay your medical benefits. It is still ultimately the business's responsibility to pay for whatever happens on the job.
Sure.
So isn't it better that we give them the option? You know, if it's just me, my wife, and my son on the business, you don't think they should have an option whether I want to purchase work comp insurance or not?
No, I don't.
Okay, thank you.
Well, let me answer the question.
That was just a yes or no question.
Well, I don't believe that it was the yes or no question. I think the reason that I wouldn't want them is that I can go sue that small business. And if that small business is an LLC or a sub-S or they've incorporated, they can shield themselves from liability simply by going out of business, simply by filing bankruptcy. In the meantime, usually when a person gets hurt, they need medical treatment immediately. If the lawsuit 18 months down the road, 24 months down the road, doesn't help that person right now. It doesn't help that individual now. If the insurance had been purchased, those benefits would kick in immediately. Healthcare coverage, temporary disability while they're unable to work. That's why they should be required to have insurance. It is a cost of doing business, and without that, you allow them to shift costs on other persons, general contractors, or local healthcare provider, or avoid costs altogether, forcing it back on the injured employee. And we've said for 9 decades in this state, 9 decades, that is poor policy.
So you are admitting that these kind of policies drive up the cost of doing business in our state?
They put the cost of injury where they should be, and that is on the business that may cause the injury.
So the answer is yes. It drives the cost up to doing business. So I'm still going to fall back on the premise that if me and my wife and my son have a construction company, it should be our decision whether we have work comp insurance. If I want to pay cash out of my pocket, if I want to pay for the medical needs of an employee, why should I not have the ability? I think it falls back on the undue burden on very small businesses, mom and pop businesses.
And the reason I strongly disagree with you is if that guy falls off the roof and is paralyzed, you're talking about hundreds of thousands of dollars, millions of dollars of costs, which you can't shoulder. If you don't think you can pay an insurance premium, you cannot shoulder that kind of burden by yourself. That would be a poor business decision, and it would hurt your ability. It would hurt your ability to go out and get contracts from general contractors because you're trying to shift your costs to them. It would be a poor business decision because you can't possibly shoulder the potential costs of a work related.
It's amazing how this world existed for so long before government got involved. Thank you.
Any other questions for this witness? Thank you, sir. Is there anyone else that would like to testify in opposition to this bill?
Good morning, Mr. Chairman, and members of the committee. Ken Legislative for Lobbyist here on behalf of the Missouri AFL-CIO.
Okay, sorry about that. Ken Menges, I'm a registered lobbyist today representing the Missouri AFL-CIO, and Missouri AFL-CIO would like to go on record in opposition to this bill.
Any questions for this bill?
Short question. Why?
Proceed.
Why? Because we feel that the workers' comp provides great protection for for any worker in the state of Missouri.
Are any of the mom and pop, mom, dad, one child construction companies, are they union members? Are they members of the AFL-CIO?
They
can be.
They can be.
They can be.
But we as the AFL-CIO would like to protect all workers in the state of Missouri.
Okay, thanks.
Any other questions for this witness? Okay. Is there anyone else here to testify in opposition to this bill? Having seen no more, we will, is there anyone here today that would like to testify for informational purposes only on this bill? Seeing none, seeing no further witnesses, this will conclude the hearing on House Bill 1528. And I'll turn it back over to my chairman.
The next bill we're going to hear is House Bill 1756 with Representative Barr.
Thank you, Madam Chair. I'm Representative Kurt Barr, District 102, and I am presenting House Bill 1756. This is the 5th year I present this bill in some version. It has passed the House once or twice and generally has a little bit of controversy with the Department of Labor. They, for some reason, don't like my bill, which if you saw the fiscal note, you could see they really, really don't like my bill. The idea of this language is to help small businesses who have independent contractors to have a little bit more certainty and at least a little bit more presumption of innocence when dealing with the issue of employee versus independent contractor. For the last 7 to 8 years, both the federal Department of Labor as well as the state Department of Labor has made a strong push to move independent contractors to employees. And that is the bias of the bureaucracies. And so this bill is designed to, well, it was designed to create a little bit of balance against that bias. So the first thing it simply says is, if a business could go to the Department of Labor and say, hey, here's my business model. This person's an independent contractor. Am I good? And the Department of Labor could come and say, okay, yeah, you're good. And then if they come back later and say, we changed our minds because we can, then the business is basically given a little bit of grace time to make that person an employee without a bunch of back taxes and back fees and penalties. That's the kind of the first part of this. The second, we just say, well, there's a couple different career fields that we're just going to assume are generally independent contractors, and so we really want the department to do their due diligence to say otherwise. And then the final part is the last section of the bill is what's called the safe harbor clause. In the federal Department of Revenue Service, the IRS, they have what's called a 530 injunctive relief, which simply says, if you're acting in good faith, you have legal opinion to say, these people are independent contractors, and you're, filing the appropriate 1099s and doing everything else in good faith, we're not going to go do a full-blown audit to determine, for IRS purposes, are you, employee or independent contractor? You can go ahead and continue to pay these people as independent contractors. And then the system is designed that, if the business model changes, that can always be revisited. And so what this last section says is, if a business here in Missouri gets IRS 530 injunctive relief, then the State Department of Labor would recognize that for employee versus independent contractor purposes. That's the intent of the bill. It just came to my attention this week that the federal Department of Labor, in their zeal to make everybody an employee, in July 15th of last year, created a 15-page summary of what they, to the term suffer or permit within the language of the Fair Labor Standards Act, which it looks like, in my understanding, that pretty much everybody who's an independent contractor is going to become an employee. So I've been told that this makes my bill completely moot because the federal Department of Labor has, across the board in every state, basically said you've got to really, really, really prove they're an independent contractor, or we're going to assume they're an employee, which was the whole bias, whole rationale for why I proposed this bill to begin with. So I'm still, I've been told that, this, was going to override my legislation. I'm hoping that, that's not the case. So I'm still wanting to push forward with this bill, but I just want to make it to your attention, this committee, that, and I can give you a copy of this, but the administrative interpretation is titled the Application of Fair Labor Standards, the Suffer or Permit Standard, and the Identification of Employees who are misclassified as independent contractors, which is, of course, the bias, is anybody who's an independent contractor is simply a misclassified employee.
Thank you, Representative. Are there any questions, Representative Davis?
McGuire.
Yes.
You may be a hero to me. Let me tell you what happened. We got a taxi company. The first person I helped, second person I helped when I was elected in 2010 was one of my local taxi companies, who all they do is provide a vehicle. They don't tell them when to come to work. They don't pay for gas. They don't pay for anything. They just say, here's the key, work whenever you want. Well, Department of Labor comes to them and says, nope, they're W-2 employees. They spent $40,000, got a hearing, and got a reverse that says, yeah, all of your people are 1099 workers. You do not fit the model of an employee. Well, this year, just a few months ago, they came after him again. Nothing changed, no change in business model, nothing has changed. They had to spend another $20,000 hiring a guy from Louisiana, I think, come up, who is a specialty in dealing with taxi companies, and got the same ruling. Said, okay, they're 1099 workers, they're not employees. So they spent $60,000 for absolutely nothing. Ruling was in their favor a second time. And they had asked me if I was going to file the bill, and I had started working on it. So I appreciate it, because I tell you, they're not W-2 employees, because they don't tell them when to come to work. They don't do anything other than, here's the key to a car. That's all we do, is we provide you with the car.
I have a constituent with a very similar story.
Do they still pay taxes to the federal government? They do, because they
Income
get a
taxes,
1099.
yeah.
They still do a 1099, so it's not like the government is losing money. It's just.
The real issue is the unemployment insurance taxes that the Department of Labor wants.
Absolutely. Well, I appreciate you bringing this bill, and I'm going to be able to forward this to my constituent, because they've been asking me to work on this, and I knew last year you had filed it, so I'm glad that you did it. And I think this is pretty evident that the Department of Labor is going after some of our businesses.
Right, because if they can't turn everybody into employee, they'll just put them out of business through lawyer costs.
Oh, absolutely. And that's exactly what was going to happen. This is a small town Joplin taxi company that they bought it right when 2010, right before the tornado happened. They bought the taxi company, and of course they've been struggling, and to spend $60,000 and get the same ruling from the same people, I think it's crazy. So I appreciate you bringing the bill forward. Thank you.
Are there any other questions? Okay, well, seeing that, is there anyone to testify in favor of this bill?
Madam Chairman, committee members, Rodney Boyd, an attorney and registered lobbyist for Dynamic Fitness, and they've lived sort of this confusing dilemma about having people that they provide services for and facilitate relationships with deemed employees. And to Representative Barr's point, they went through a federal audit, which was triggered by a state complaint, where the state of Missouri Department of Employment Security, Department of Labor, contacted the U.S. IRS and said, hey, we believe Dynamic Fitness has people that are personal trainers that are employees. After going through a state case and a federal audit, they were granted what he referred to as 530 Treasury relief. Sort of getting familiar with what they went through, they spent over $200,000 fighting this issue. Less than 5% of the folks that seek or try to get 530 status in the country are granted. It's a very rare status for the U.S. Treasury to grant, and that's after you've gone through an audit. And basically what Dynamic Fitness does is they vet independent contractor personal trainers for fitness centers. So I open up a fitness center, I don't know who's a personal trainer or not. I go to Dynamic Fitness, and they're sort of or a broker or a middle person for my gym and personal trainers. They make sure personal trainers are certified, have certain training, know what they're doing, and then they introduce those folks to certain fitness centers, and they're out of the way. They have nothing to do with training regimen, who the personal trainers train. Every personal trainer that was interviewed by Employment Security and by the IRS said, we received a 1099, we paid our taxes, I own my own business. The folks at Dynamic Fitness don't tell me who to train, what type of training to do. They just make sure I'm legit, and they have relationships with certain gyms throughout the state. So, when you think about what they went through, and you go to the U.S. Treasury's website, and they have, as an example of an independent contractor or personal trainer, it's just shocking that this company had to go through this for 2 or 3 years. I talked to the former director, Damon Porter, his predecessor, Nimrod Chappell. We went through this at length. They both agreed that in this context, Dynamic Fitness was not the employer. They gave every record that the state and federal agencies asked for, proving that their relationships were independent contractor relationships, and they paid all the taxes accordingly. So this legislation is really, for our purposes, designed to avoid what Representative Davis just highlighted. Dynamic Fitness has been granted 530 status by the U.S. Department of Treasury after an audit. They're just wanting some certainty that in the future, the next administration or down the road, the new employment security agency won't come back and ignore that $200,000 that they spent, the audits that they underwent, and the dilemma that they went through. And by the way, there is no circumstance under which their personal trainers have ever been treated as employees by the federal government or by them or anybody else. So for our purposes, this legislation just gives some certainty to what they do going forward, that they would be protected from any kind of new second look at this, and at least require the state agencies to acknowledge that when you've gone through an audit, and you've been granted this status, it means something. Otherwise, the agencies can come back every year and say, we're going to try this again and again and again. So that's why we're in support of this bill. We believe it's just kind of makes sense and provides some certainty to, especially to folks that have gone through the process and been granted this very difficult to achieve 530 status.
Thank you. Now, is it true that our Department of Labor contacted another state's Department of Labor, and that seems like an overreach to me, but well, I just want to clarify.
Madam Chairman, to your point, and I wasn't even going to go there because we're dealing with this in Illinois, but at some point during the state of Missouri's investigation, the state agency contacted their sister agency in Illinois, reported their investigation, and suggested that because Dynamic Fitness provides the same service in Illinois, that the Illinois Department of Employment Security should also conduct an investigation. So we're fighting this in Illinois as well. There's legislation filed very similar to this by Senator Kyle McCarter, moving it through the process there. We have had conversations with Governor Ronner's office. His new agency is taking a second look at the case. And the troubling fact there is no one filed an unemployment security claim with the state. This was a case that was open because our agency contacted their agency and said, you ought to take a look. We gave them everything they asked for. We had 180 or so personal trainers write petitions and turn over their 1099 documents to the state of Illinois to say, hey, we're not employees, and if you deem us as employees, we're going to stop because we run our own training businesses. And so, yeah, it's been a kind of a nightmare for these guys. And one of the things that's happened is Missouri has settled its case, and the IRS has given them this status, but they still have a pending case, year 3 now, with the state of Illinois that's just dragging on and on and on. So we're hopeful that the Ronner administration, now that they seem engaged in our conversation, they're going to give us some sense of relief, and we're also going to try to pass legislation in Illinois to the same effect.
Are there any other questions, Representative Allen?
Just to make a comment, or Madam Chairman too. So thank you for bringing this up, Madam Representative. So does this sound like Labor Department's going after private businesses?
Well, I can speak about Dynamic Fitness, and clearly they feel like they have been assaulted and assailed by our department because they produce all the documents. Even the investigator that came down initially said, looks to me like you guys are okay, but I got to send this up to the higher levels, which that investigator did. And ultimately, we still had this reporting to Illinois. This has drug on forever. And once we got the 530 status from the U.S. Treasury, we celebrated. Said, hey, this is great. Now we got some sense of certainty. And the federal government has said that the people that we are working with are independent contractors. Hey, the state ought to acknowledge this. But then there's, as Representative Davis pointed out, this possibility that the state could come back and trigger a new investigation next week. So we just want some sense of certainty that when you go through these audits and you open up your books and you're examined from head to toe and you're proven that you meet the standards of the law as an independent contractor, that means something. And right now, there's not that certainty with the way the state could practice and come back and say we want to trigger a new investigation again.
I would just say maybe these state workers in these labor departments don't have enough to do of real stuff, so they have to go through against other entities. Thank you for coming.
Thank you. Any other questions for this witness? Okay, thank you so much. Is there anyone else to testify in favor of this bill? Is there anyone to testify against this bill?
Once again, I'm Mark Moreland, and I'm on the executive committee with the Missouri Association of Trial Attorneys. And first, let me express some sympathy with Representative Davis's client or constituent. It sounds awful. Also to Mr. Boyd's client. Certainly sounds like something that no one should have to go through, particularly more than once. That said, the concern that we have about the bill is that the bill leaves it open to the possibility of misclassification of employees. And what that does in a workers' compensation setting then is it deprives individuals who otherwise would be covered under the Missouri Workers' Compensation Act of the coverage they need. So the example that I would use is simply the roofing company. The roofing company may have 5 employees in the office. They get a workers' compensation policy that covers those 5, but then makes the announcement that the roofers that they hired or roof buildings are only done on a case-by-case basis, and therefore they should be given 1099s. And they're denied coverage then and access to benefits under the Missouri Workers' Compensation law. And you can see that in the areas of construction, and I'm sure in other areas as well. And so we raise that concern. We think it is legitimate for state agencies to investigate the possibilities of fraud. The latest figures that I have, findings of fraud doubled in 2009, between 2009 and 2010. So I think it is appropriate to investigate. I would agree. Once would seem to certainly be enough in terms of an investigation. That said, this does eliminate, from what I can see, certain penalties and interest for fraud, and therefore I think it encourages fraud. The other examples that I've given, I gave in the previous bill. If employees are misclassified, say with, again, using a roofer as an example, those people are uncovered in workers' compensation, but then that roofer can go out, show his workers' compensation coverage certificate to a general contractor, but the people that he sends over to do the work are actually uncovered. When they get injured, then the general contractor's workers' compensation coverage may be the one that has to pick up for those folks. So for those reasons, I think we're generally opposed to the bill. I would point the committee, there was a study done in 2014 by the National Employment Law Project. It's 32 pages, so I won't read it today. But it does show that misclassification costs states money in unemployment benefits. It would cost this state money in the admin fund. That's the fund that goes to fund the Division of Workers' Compensation, so that it doesn't come out of the general revenue of the state. So misclassification costs states money, and we'd be happy to share this study with anyone who would like it.
Thank you so much. Are there any questions? Representative Davis.
What would your remedy be for circumstances like my taxi company, where it's already been ruled one time, and like was brought up, maybe the next administration or the next department director or the next person in charge decides that they're going to do? What would you think would be the remedy if there's already a ruling one time, that they don't have to go through it again and again and again when nothing has changed in the business model?
I haven't thought that through, and so I don't want to just throw something out on the table.
Because I would like for it to be the departments make a decision themselves through rules or regulations, whatever the case may be, that says, okay, if we have a ruling by the department, then unless there is a change in the structure of the business, and that's what I would like them to have done to my taxi company, to say, okay, well, this person filed unemployment, re-justify your 1099. Okay, well, they go through that whole list of qualifications or disqualifications. Nothing's changed. They immediately say, okay, nothing's changed, so we're going to not pursue this, but they didn't do that. Right. So I'm just trying to find out what a remedy would be.
Right, and I think there should be some remedy, and I would even go so far as to say I think there should be some way for the business to recover its costs of litigating the issue a second time. If they can find no material change that caused that. The other thing is maybe some level of reciprocity. You know, if Missouri has done an investigation, or let's say Illinois has done the investigation of Dynamic first, maybe Missouri's department should accept Illinois' department's findings that they were okay, that they were indeed independent contractors, to avoid a multi-state investigation.
I think Representative Barr is trying to find a solution. And if the departments don't find solutions to the problems they're creating, then unfortunately legislators have to go through and try to find a remedy for the people that they were elected to support.
Sure.
Okay, I'm sorry. Go ahead.
Well, I was just going to say, our concern is that misclassification do cost. And we do see, and labor unions see, misclassifications in construction industries and trucking industries. There are industries that misclassify employees in an effort to save costs. And so our concern is that just as we don't want to unfairly go after someone who's a tax-exempt, I mean, legitimate 1099 employee, seems to me it wouldn't take very long to figure that out. It seems to me.
Yeah.
You know, by the same token, those who deliberately misclassify, who attempt to shift costs to others, should be treated with penalties and interest and monitored. So that
I think one of the things the government does is they penalize everybody rather than penalizing the crooks.
It is, sometimes it's hard to tell the difference, I suppose.
Great, appreciate it, thank you.
Thank you, Representative. Are there any other questions? Okay, thank you so much. Anyone else to testify in opposition? And Representative Barr, I do have a question. Your clients, or this Dynamic Fitness, their expenses were solely attorney fees to try to fight our government.
Well,
right? I mean,
most of it was
most
attorney
part.
fees. They paid a little bit of money to the department so the department could save face and make it all go away. But most of this was attorney fees.
Attorney fees. Wow. Maybe perhaps we should count that. Go ahead.
Thank you. Again, Ken Menges, representing Missouri AFL-CIO. And Missouri AFL-CIO would like to go on record in opposition to this for the same concerns previously stated about the possibility of misclassification of workers.
Thank you so much. Any questions? Okay, anyone else in opposition? Okay, anyone for informational purposes only?
Madam Chairman, Representatives, my name is David Claridge. Today I'm appearing, I guess, on behalf of my law firm, Reisman Berger. I'm testifying for the purpose that I brought to Representative Barr's attention, Administrator's Interpretation 2015-1, which was handed down by the United States Department of Labor on July 15, 2015. The discussion that you've had thus far is interesting, but might somewhat be preempted. Employees want certainty. They want to be able to know whether or not they're employees. They want to know whether or not they're independent contractors. And employers want to know how to classify them, at least those that want to act in good faith and do the right thing. The problem, however, may have been complicated by the United States Department of Labor, because according to this interpretation that was handed down, it basically compels through a reorganization of the criteria to determine whether or not you're an employee or an independent contractor. It compels a shift from independent contractor to employee. Basically, if you will, a presumption in that regard. I would encourage you to take a look at it because the consequence is dramatic. The question is, however, does it have the effect of law? Upon contacting the House Committee on Education and Labor, talking to the congressman and pointing this out, they understand that it's a significant issue and that the administration has been contacting states, departments of labor and encouraging them to use this criteria to determine whether or not somebody falls within the independent contractor employee classification. But there's no law per se upon which to rest. We've always gone to the Internal Revenue Service and the 20-point test. The problem is that we don't know whether or not the Department of Labor will trump the IRS or vice versa. I do know that there are efforts right now to address this issue statutorily, to address by legislation this issue at the federal level. But until that is done, we are going to have an issue with the United States Department of Labor and their interpretation. So I brought this to the representative's attention because this doesn't solve it. And unfortunately, Mr. Boyd's issue and Representative Davis's issue are all falling within the uncertainty that's created as a result of the Administrator's Interpretation 2015-1. And so I wanted to bring it to your attention because it's a big one. It affects major companies. One of the companies that I represent is the largest cooperative in the world, and it turns franchises into employees. And you can only imagine with withholding and workers' compensation and tax consequences across the board, healthcare benefits, you name it, it could be dramatic implication. So I just wanted to encourage you to take a look at that first, because I'm not quite sure that on a state-by-state basis, we're going to be able to solve this problem.
Thank you so much. Any questions?
Thank
you so much. Anyone else for informational purposes only? This concludes the hearing on House Bill 1756. Next, we're going to hear House Bill 1955.
Thank you, Madam Chair, members of the committee. House Bill 1955 also concerns workers' compensation. We've had several issues this morning. This is refiling Conference Committee substitute for Senate Committee substitute for House Bill 615 last year, which was my second go-round. I think we've gotten every issue ironed out. And this is the one that died a rather tragic death as the last bill on the calendar last year. It has several features which I'll quickly try to go over, and I think it probably will refresh your memory. Started out as an exemption for veteran organization volunteers from workers' compensation, and had several items added. One was exemption of crop dusters from workers' comp. They are generally 1099 workers. Final payment evidencing full payment of medical benefits was a point of contention, but we had this ironed out in the Conference Committee substitute, which did not have a chance to be heard on the floor and passed last year. I think we've got that part worked out. It would take away, there was a push to get to certified mail. This just says that it will be prominently displayed that this is final payment. Also works on some issues in the second injury fund liabilities, which was tackled in 2013 under Senate Bill 1. There were a couple items to take care of there, so we've included those. Be glad to get into that if you'd like. Split point changing from $1,000 to 20%. Provides a quarterly reporting choice for construction employers. And I think that is all the features.
Thank you, Representative. Are there any questions for this? Okay, is there anyone here to testify in favor of this bill? I'd like to also remind everyone to fill out a witness form if they're going to testify today.
Good morning, Madam Chair, members of the committee. Mark Bruns on behalf of the Missouri Subcontractors Association.
And Nancy Gibbs on behalf of Construction Employers Coalition.
And we are part of the CEC, so appreciate Representative Dorman filing this bill. We're in favor of the bill, in particular, section 287.975, which is on the last 2 pages of the bill. We don't pretend to be experts in work comp, so bear with me if I read from my notes here. What Representative Norman talked about on the mod factor, what it does, it allows any contractor the flexibility to pay 20% of an injured worker's medical costs instead of $1,000. It doesn't reduce the benefits to the worker, and the employer is still obligated to report the injury. The second part we're interested in is on the very last page of the bill. and it allows calculating premium credit modification. It allows the contractor to pick the quarter that he or she will submit the payroll information upon which their premium credit is based. So it provides for flexibility for the contractor. We'd be happy to answer any questions.
Are there any questions for this witness? Seeing none.
Thank you.
Thank you.
All right.
Easily done.
Anyone else to testify in favor of this bill?
Madam Chairman, members of the committee, Rodney Gray, appearing here on behalf of Mitchell International. Mitchell is a claims management company that operates in the workers' comp field, usually working for people who have companies or insurance companies who have a lot of exposure in the workers' comp field. Examples in Missouri would be like Missouri Employers Mutual Insurance Company, Private Trucking in Springfield, people like that. Just want to mention two things. We're very much in support of the bill. Particularly, like the previous witness, we're only interested in one of the provisions that's in here in 287.140.1, the notice of dispute resolution language. We think brings a lot of clarity to that provision, much like it's making it very similar to the explanation of benefits language that most of us are familiar with, and we get notice from our insurance company in regards to how that determination has been made in regard to that. So it makes it very clear in that area between the provider and the insurance company how that's handled. The second part of that, you heard the sponsor mention that it eliminates the requirement of certified mail. That's not ordinarily done in the ordinary course of business. Let me just point out that for one of our clients, and particularly any one of those clients, it adds the expense of certified mail to do this. It adds about $35,000 per client across the state. So it's a very expensive provision that we currently have in law. It's not seen anywhere else. And so for that reason, we're very supportive of the compromise language that's been accommodated in this bill. And would ask that you support it. I'd be happy to answer any questions.
Thank you. Is there anyone else that has questions for this witness? Okay, seeing none, is there anyone else to testify in favor of this bill? Okay, seeing none, is there anyone to testify in opposition of this bill?
At this point, no introductions.
Well, I am Mark Moreland still. At this moment, I'm still on the executive committee of the Missouri Association of Trial Attorneys. We oppose the bill. The aspect of the bill that we would oppose is the removal of those engaged in crop dusting, seeding, and spraying or fertilizing operations from the role of from the classification of statutory employment. And the reason that we would oppose that is, again, it removes them from coverage under the Missouri Workers' Compensation Act. If there would be a plane crash and someone would die, their widow would get 2/3 of their average weekly wage for the rest of her life to support her, unless she remarries, and in which case she would get a 2-year lump sum payment. Likewise, if there are minor children, they would receive benefits through their 22nd birthday. I think it's wrong if they attend college. I think it's wrong to remove those types of people in a relatively dangerous occupation from the coverage of the Act and to shift the burden of that loss onto that individual family. The other is exempting veterans organization volunteers who are not paid wages from coverage under the Act. Volunteers have essentially been covered since the inception of the Act. And again, I think you're opening the door. If you're going to do volunteers of veterans organizations, you can do volunteers from other places. But volunteers can do things that are exceedingly dangerous. They may not be well qualified to do them. They may receive injuries that affect their family every bit as much as someone who goes to work and gets injured. And so they should be covered under the Workers' Compensation Act as well. I mean, an example that I'll use is I represented a gentleman who was volunteering for his church. They were erecting
one of these gymnasium buildings, and he was seriously injured. He fell from a scaffold. Had he not had coverage, his family would have lost their home. So, you know, when you start exempting people from the act, you begin to shift risks and costs to other places. Likewise, as I said, the act covers, protects employers, because if this gentleman is not a statutory employer, now his family has the ability to sue his employer for injuries if the employer is responsible for them. And but that can cost the employer a lot more than his premium on his insurance policy.
Thank you. I just wondered, what is the maximum amount that an attorney can receive from someone's claims like this? I mean, you know, our goal and your goal is to make sure that people are compensated, but it seems like such a huge amount goes to the attorneys.
Well, attorney's fees are capped at 25%.
So if someone gets $50,000 or $200,000, you're going to take $50,000 from this person that really needs it in their time of dire need here.
Well, if I choose to take the full 25%, many times I do not. I take less than that.
You know, and I'm thinking that maybe perhaps a cap on attorney fees, because really what we're worried about is the person that's hurt. So perhaps 5% I think would be really sufficient. But thank you so much. In the essence of time, I will see if anyone else has any questions. Oh, okay, thank you so much. Is there anyone else to testify in opposition?
Madam Chairman, members of the committee, Ken Mendes again for Missouri AFL-CIO, and we go in opposition just that we do not want to see the door opening or allowing different groups to get out of workers' comp and what it could do to that. There are many good things in this bill, but that's the one thing we do oppose.
Thank you. Is there any questions for this witness? Is there anyone else to testify in opposition of this bill? Seeing none, is there anyone to testify in for informational purposes only? Seeing none, this concludes the hearing. Thank you. Oh, yes, Representative, go ahead.
Just real quickly, I think there's lots of good features in this bill. I will say I'm a little surprised. 2 years ago, had an issue with MATA, and they came to me and we worked all that out. And I was surprised to hear the testimony this morning. I think any of us who sit in tractor seats as opposed to executive chairs know that crop dusters basically are 1099s on most issues, and to not exempt volunteers at veterans organizations seems rather counterintuitive to me. But thank you very much. Appreciate your time.
Representative, that concludes the hearing on House Bill 1955. Thank you.
Well, I got here for the end.